second, see if we can get Mr. Walker to hear us. Mr. Walker, can you hear us? All right, Mr. Dominic, have you had any interactions specifically with Mr. Walker? I know he's in the halfway house. I understand that.
Yes, I have not. I received the filing that he filed on March 6th. That's the only communication I've had.
Okay. Case. Sorry, I'm looking at filing. Laura, is there anything specifically I need to review in his filing from update or point?
No, I don't believe so. I'm emailing the contact person that I have at
The residence.
Yes, at the residence, just to see if there's anyone there. If she gets the email, if there's anyone there who could help out. So.
Okay. Sounds good. Tony, sorry. Hold on 1 second.
That's okay. Can I go forward, Judge? Oh.
Yeah, go ahead. You can go ahead and go forward, yeah. And then
Okay.
we're able to get in touch with him. I'll hear from him.
All right. Judge, if you recall, I represent Petitioner Brian Doss, and we filed a motion for default judgment back on January 19th. And accompanying that motion was our USCR 15 certificate of default. And most relevant to today's hearing is paragraph 1, in which we state that Defendant Walker was personally served on the 16th day of July 2021, and the Sheriff's entry of service was filed on July 28, 2021. That the defendant filed no responsive pleading in the case as to him went into default on August 27, 2021. Very briefly, Judge, all of the other defendants that we didn't settle with also are in default. I would just like to point out that in paragraph 3 of my certificate, I left out the name Gary Ruiz. It should say Defendant Gary Ruiz was personally served on the 3rd day of August, etc., etc. So all of the defendants are in default. I sense, Judge, that this case is similar maybe to one of the other cases before Your Honor this morning, in which a pro se defendant thought he filed an answer but didn't. That's just the impression that I got from Mr. Walker. If you recall, we had a hearing on January 23rd.
Mm-hmm.
However, in that regard, Judge, I would like to direct your attention to a letter. In fact, Mr. Walker has filed numerous papers in this case, just not an answer.
Yeah.
And one of the papers he filed it was filed on April 10th. And it's a letter, and if I may, it says, I, Albert Walker Jr., received the package, referring to a request for copies that he had previously sent to the clerk. But there are no documents in reference to the documents that I filed in the court. Can you please send me those documents? I'm not sure exactly what that means, but it may be that he is saying, hey, I don't see everything I filed. You need to give me everything. And I would like to point out that the clerk of the Superior Court, Fulton County, responded that day and said, your request has been received and filed in our office. The documents were all letters. See attached. The documents were all letters. So the only interpretation of that is that if Mr. Walker should have known in April of last year, a year ago, that there was a problem, that his answer wasn't filed. No one has done anything to push the case. There hasn't been any discovery. All that. I don't want to get into my client's prior attorney's actions because a default judgment should have been filed at some point before January of this year. In regard to the filing that Mr. Walker filed on March 24th, it's like a 49-page document. It's hard to make it. It is a shotgun pleading of the worst order. And Mr. Walker's trying to be smart, trying to show everyone how smart he is. I don't know if Ms. Strong has thoroughly reviewed that, but it includes a motion for default judgment against my client for failing to respond to a counterclaim. So that's the kind of litigation tactics we're dealing here with this person. No cost have been paid, to my knowledge, and Mr. I don't want to make a misstatement of the court, and it's difficult to get information with the current computer situation, but to my knowledge, he has not paid cost. This March 6th filing is not an offer to go forth in stanter. It is not. Part of it does include a verification, but I would submit it's not under oath. And this case has been in default for so long that we're asking that it come to an end. Mm-hmm. And Judge, I don't want to get far afield. I think the record speaks for itself, but as indicated on this April 4th letter, the April 5th, and it was filed April 2nd from Mr. Walker, he wrote that from federal prison. And that kind of raises the question, does his incarceration have something to do with this case? Well, in fact, it does. I don't want to testify, but I think this is relevant because, Your Honor, we're not trying the case, but Your Honor can take a look and see if there is a meritorious defense here. And Mr. Walker was tried and convicted for arson against this property and insurance fraud. That's what this is about.
4 times.
So his claim for title, so that he can assert a counterclaim against my client for damage to the property, he's the one that, he was convicted for burning the house. So this is not in good faith. It's not a meritorious defense. Mr. Walker is not an innocent party. Again, I don't want to get too far into that because of evidentiary issues, but I would ask the court to take cognizance of that. And I did send Ms. Strong some copies from Pacer from his criminal case. But the main fact is that Mr. Walker never filed an answer. He was on notice in April of last year that there was a problem with the filing of his answer. He took no action. We filed our default judgment. He has not responded to the default judgment. He did file the March 6th paper, and it is insufficient under 911-55B to open the default. Therefore, we would ask for a default judgment.
All right, thank you. Ms. Strong, were we able to get a hold of anyone at the facility?
I have not heard anything back.
Okay. Okay. All right. Well, giving him the opportunity, I think, to be heard, and yeah, no, obviously I've looked at the record now as well, Mr. Tommy, as we went through, and no, it's very clear. I mean, he states he's filed an answer, but there's nothing obviously in the record as to that. In fact, he's actually claiming he filed an answer before he was even served. I'm not quite sure how he would do that. So if you want to go ahead, have you sent a proposed order yet?
Judge, I have not. I apologize. My recent mishap is setting me behind. By the way, Judge, I very much appreciate your indulgence for saving the embarrassment of, being on a Zoom call with 30 lawyers with my eyes black.
I totally understand. I totally understand. I had a mishap with a candle falling and hitting me in the face. So I actually had a black eye a couple weeks ago. I get it. It's not a problem. I hope you're feeling better.
I can get that to her.
Yeah.
By tomorrow.
That's great. Yeah, that's great. We'd like to get it before the end of the month. So.
Absolutely.
Okay. Anything else, Lauren?
I don't think so.
Okay.
All right. Thank y'all.
All right. Sounds good.
May we be excused then?
Yes, you may. Thank you.
Thank you, Judge. Thank you, Laura. Bye now.